Hello and welcome to Legally Speaking with me, Tarun Nangia. Today we're going to discuss the topic of arbitration and ADR, which is very important in a growing economy like India. Also, we focus on the comments made by Justice Rishikesh Roy at the India leg of the ADR week that happened in the New Delhi at the Oberoi Hotel recently, where he was pretty frank on his views on arbitration. He made comments like the state of Indian arbitration is like an overloaded truck going uphill and struggling to go up. He also spoke about delays and adjournments and made a lot of points. But that's what my panelists to ponder about. They are the experts on this. Let me welcome my panel today. Neeti Sachdeva, the Secretary General of the Mumbai Center for International Arbitration, joins us. It was her event. Good to have you on the show and looking forward to insights on this subject. We have with us Tahira Karanjawala, partner from Karanjawala and Company. Good to see you, Tahira, and looking forward to insights. We have somebody who has very strong opinions on the subject of arbitration in India, Senior Advocate Percival Bilimoria, who does a lot of arbitration, international as well as domestic. Good to see you, Mr. Bilimoria, and looking forward to your frankness in this show as well. I have with me Advocate Karthik Seth, who is a litigator and also does arbitration. Good to see you, Karthik. He could make it in time. He had to come in from Jaipur, but I'm happy he could join us on the show well in time. Good to see you. We have a first-time guest on the show who I want to welcome, Sudeshna Guha Roy. She's a partner with Saraf and Partners. Good to see you as a first-time guest on the show and look forward to see you often and looking forward to some interesting insights from you on this topic as well. At the outset, let me request Neeti Sachdeva, Secretary General of the Mumbai Center for International Arbitration, to summarize what happened at the India ADR Week's speech by Justice Rishikesh Roy. Maybe give her opinion, and then we move on to take individual comments. Over to Neeti for this. Thank you.
Thank you so much, Tarun. It's always a pleasure. And as always, a last minute googly by Tarun to tell you to do things. He will keep telling you, oh, it'll be simple, just few questions. And then he'll be like, okay, go on, summarize what Justice Rishikesh Roy said. But I think it was very interesting to hear Justice Rishikesh Roy. It was a very good speech on the humor with arbitration, with a bit of, his take on where Indian arbitration scene has actually reached. I'll try my best to actually summarize some of the points which he brought out. I think he started off by talking about that how arbitration was supposed to be fast, flexible, cost effective. But what we are seeing today, as you said, it has become an overloaded truck which can't go uphill. And one of the things that he said is that probably the reason is that because you have still very frequent adjournments in arbitration. And his opinion was that one of the reasons you have these adjournments is that because you have the lawyers practicing in the courts, also practicing in the arbitration. And you will very often hear a client saying that my lawyer is busy in a court on his legs. Can you please push the arbitration a bit more? He went on to delve on that then, that how the too many practicing lawyers and at times too many retired judges as well have sort of taken over the seat of arbitration and it's not moving. I have to say it was quite refreshing to see a sitting judge talking about it, how at times retired judges are not able to probably enhance the cause of effective dispute resolution as we would have probably expected it. And it mentioned that, what our dear Fali Nariman always said about having an arbitration bar, which we now, of course, have the arbitration bar of India, that may make an impact on having people specialized in arbitration and making it cost effective. He also spoke about one very pertinent point, which the current Chief Justice of ours is taking up, which is to appoint young, talented arbitrators, lawyers as arbitrators. And he, in fact, went on to make a comment, which was interesting for me to say that currently the Supreme Court seems to be appointing more young lawyers as arbitrators than even the retired judges. I mean, I haven't done my research on that, but coming from Justice Rishikesh Roy, I'll definitely take that. And I have an uptake on that as a comment when you come to me on that part of it. The third thing he spoke about was how, at times in India, arbitration, you have this example which William Park gave was of high quality, low price, and also things of fast service, and how in India you can have an arbitration where you can only pick two out of the three. So you can have a fast service and a high quality, but then you will not have a low price, and a different combinations of these three, which was very interesting to hear again. And I will be very happy to comment on how institutional arbitration is making a difference on that. And I think the last thing that he spoke about, and he said that one has to maintain a balancing act, is arbitration should not be a two-step process, what it has become. People go to arbitration, but then ultimately end up in court. And his take was that the courts will have to be pro-arbitration, to have a hands-off approach to say that you chose arbitration, that's what you stuck with, and that's where it ought to be. So I think those were the 3-4 main key points which he touched on in his keynote address during the India ADR week in Delhi.
Thank you, Neeti, so much for explaining this to all of us. We discussed this today also because Justice Rishikesh Roy made very frank comments. As a sitting judge, he came out, very, very forthrightly on what he felt. Secondly, we are looking at about 13 to 14 lakh crores being invested in infrastructure in India by 2033. What that means is that so much of money will go into infrastructure in India, which will create, greenfield infrastructure, which is new infrastructure, which will lead to a lot of disputes. And both on the commercial litigation side or the arbitration side, we will be short-staffed. It's not about having less or more work. There will be so much work that India wouldn't be able to handle in courts or outside courts, which is arbitration. Given that as a base, and then what Justice Rishikesh Roy said, let me request Senior Advocate Percival Bilimoria to give his opening comment. Over to you, Mr. Bilimoria.
Thank you, Tarun. So I agree with the comments entirely. I think, look, there are three objectives to arbitration. The two which are oft touted are speed and cost. Right now, I don't believe that arbitration is necessarily cheap. Right. So the cost issue, I think even globally, I don't think anybody really looks at arbitration as a cheaper option to court. In fact, it's probably the other way around. And this has been recognized. And please remember that when we talk about arbitration, all disputes can be arbitrated. We are specifically talking only about commercial disputes, where if the claims are very high, for example, in infrastructure projects, the fees can be relatively higher than just going to court. The third thing that we don't really mention is the fact that ultimately party autonomy should not really mean that, look, even if the decision is wrong, no litigant is ever happy if he gets a wrong order from a court or a wrong award, what he perceives as wrong. All right, but there are some, and I'll be very frank here, there are some very horrid awards that I have seen. And we should also remember that it is not just jurists or even lawyers who are arbitrators. Very often people opt for technical people, engineers or accountants who can be arbitrators. I think there is a lot to be said for, having experienced jurists. But at the same time, I think my experience is that if you have a retired judge as an arbitrator, then there is a tendency to be extra procedural. I think that's one thing that one can say as something that can change a lot. I think people from the bench have to realize that this is no longer court, and CPC doesn't strictly apply. And the other issue is that the institutional arbitration should come into more prominence here. A large percentage, I don't know what percentage, but a large percentage of arbitration in India is ad hoc. Ad hoc means that the arbitrator can set its own procedure in consultation with the parties. Now, that doesn't always work out well. And in institutions, you have case management, which is a very important aspect, which lends support to the arbitrator in case management. And there is peer review of the awards. A lot of time when you go to, say, ICC or some of these, the award is a little delayed simply because, the award goes back and forth during the peer review, which ultimately is not a bad thing.
Mr. Bilimoria made one highlighted point is peer review of awards, and that is something looks like I remember you have taken this issue up with me even on one other show and privately also spoken about how highly you value something like peer review of awards. That is something that we will get to discuss. I'll go to Tahira Karanjawala, partner with Karanjawala and Company. Let me read out, Tahira, one statement of what Justice Roy said. Arbitration is no longer the sleek sports car that we once envisaged, and instead it has become more like an overloaded truck struggling up the hill while we watch from behind wondering, wasn't it supposed to be faster? So the last line gives it away. Justice Roy wants arbitration to be faster. Uh, uh, Given that as a base, give me your opening comment on this issue. What do you, Tahira?
Thank you very much, Tarun. Tarun, I think Justice Roy has sort of highlighted a very important problem which has emerged since the arbitration landscape in India has been developing. I think it largely stems from the fact that litigation has been a very sort of concentrated in the hand, sort of with a few people. The same litigators go to court, the same litigators are now doing arbitrations, which is, I think, what he meant to highlight. So you often find a situation where adjournments are being taken because a particular senior counsel doesn't have dates available or is only available in the evening slots and not in the morning. Similarly, the trust that people appointing the arbitrators, and often these are appointed in consultation with the lawyers, who are advising the clients in the matter. The trust that they have is also more in the judges because they are used to appearing before them. There's a certain presumed level of knowledge of procedure, which leads to a situation where increasingly the preference is to appoint retired judges, also because you feel that their awards will be upheld without too much interference from the courts. So this has led to a situation of perhaps, what Justice Roy was highlighting, where the entire landscape is like an overloaded truck. I think, it can be sort of resolved if you have a robust arbitration bar that comes up. Clients are happy to go with lawyers who confine themselves only to arbitration. Actually, now increasingly, senior counsel and in fact even counsel have to pick whether they want to concentrate on their court practice or they want to concentrate on arbitration, because it's not only a matter of dates. Now, with the Arbitration Act imposing a 1-year period after completion of pleadings for completion of the arbitration, you don't get very many extensions for filings as well. So even for advocates who are simply filing the pleadings in the matter, you need to take out adequate time to be able to devote to meeting those deadlines. So I think if an arbitration bar develops, then this would sort of lessen the overload, and you'll have more work spread out over many more persons. And this would, sort of lessen the burden on the arbitration landscape. And the second thing is what Percy sir also said, that often if you have experts, they could help reduce time taken for the arbitral tribunal to digest the dispute. Accountants, engineers, often these people are very familiar with the subject matter of arbitrations, more so than judges. They can also help to reduce the procedural sort of the tendency to be over procedural, and so it can cut down the time required in coming to an adjudication. So I feel that both in terms of if the pool of arbitrators is widened and the pool of lawyers is widened, this is probably going to reduce the burden on arbitration as a concept in India.
So pool of arbitrators and the pool of, in a sense, lawyers who focus on arbitration more is what you're suggesting. I'll go to Advocate Karthik Seth. Let me read out what Justice Roy said, Karthik, to you before you can make your comment. Justice Rishikesh Roy said that we are slowly turning arbitration into what it was never meant to be, just another formal process with more adjournments, more delays, more paperwork, and less arbitration actually getting done. Indeed, a very strong comment coming from Justice Roy. Over to you for your comment.
Thank you, Tarun. I completely agree with all the fellow panelists who have spoken before me, and also with Justice Rishikesh Roy on what he pointed out. The only thing which I would want to add to it, it's not only with regard to adjournments per se. Definitely, there are other things as well. And me being a litigation lawyer who's shuffling between courts and arbitration, I wouldn't want to say that we need to specialize just with regard to arbitration. Definitely, we need to have a robust mechanism which has an arbitration bar, which has a particular mechanism in place where focus is shifted when timelines are set. In fact, I'm doing a couple of international arbitrations, for example, in SIAC or even in London International Arbitration Center. There is no further time after the time which is given to the arbitration tribunal. In India, the problem also lies, in my opinion, with the law. Like, you have a 29A4 which is there. After a lapse of 1.5 years, another an extension can be given for 6 months. I personally feel I've been in an arbitration, I don't want to take names, but where a learned retired judge has come to the fore after the judgment was reserved in February of this year, comes to us in July and says, I've forgotten everything, I was outstation, let's restart the hearing. You file an arbitrate, you both give consent for extension, you file another extension application. I mean, so the onus lies on. I appreciate the fact when Justice Rishikesh Roy is saying, and when Neeti said that there needs to be more research on this aspect, that there are more young arbitrators being appointed. That is the need of the hour. More, because see, it cannot be, it has to be from both sides. The adjournments are not being only sought by the lawyers who are appearing in courts and arbitration. It's also because of the retired judges. And moreover, when he pointed out a very humorous quote on Tendulkar and Federer's fictitious this thing, that was very, I felt it was very apt, very on point when he said that things like arbitration is going to become tennis rackets which we use as mosquito rackets. Because I mean, we have the biggest demand for arbitration law in India, but at the end of the day, the arbitration mechanism is not being used properly. And there I completely agree with Percy sir when he said that we need to make institutionalized arbitration the only way forward. The ad hoc arbitration, which is almost whatever 70-80%, has to go away in a streamlined manner. And I personally feel that wherever the Supreme Court is heading, and a top 5 Supreme Court judge saying the same thing, he's in the collegium as well, he can bring out changes in the manner in which he wants. So I mean, I welcome everything what is being said, but I hope it turns out to some action as well.
Point very well taken, Karthik. We all hope that some action will be taken. We'll go to Sudeshna Guha Roy, partner with Sarafel Partners. Sudeshna, on the two comments of Justice Roy that I read out, the first one, which was, wasn't arbitration supposed to be faster? Second was what I just read out on delays, more paperwork, more adjournments, and the expectation that now this is coming from, as what Karthik said, a collegium member, a judge of the Supreme Court. Do you think finally even the courts have recognized that arbitration has not turned out what it was expected to do in terms of dispute resolution faster for commercial parties who have bank loans to service and who are looking for quicker resolutions? Your opening comment in detail on this.
Hi, thank you for having me on the chat and show, Tarun. And I just want to start by saying that I completely concur with whatever my other panelists over this in this show has opined. And just to address the elephant in the room, that Justice Rishikesh Roy's comments, though humorous and has just come now in the heels of the ADR week, the feeling and the sentiments, unfortunately, in this entire sphere of arbitration has remained constant. If you look at the remarks of Justice A.P. Shah in 2015 about the arbitration, about a dedicated arbitration arbitration bar, about an arbitration council of India, about having arbitration benches, these problems still persist. Yes, having an arbitration bar is a welcome step to that extent. But if you look at these issues, which today was, very nicely, in a very nuanced manner, articulated by Justice Rishikesh Roy, but these problems have plagued the arbitration, because it is, I would say that at the cost of, I think, upsetting some people, that arbitration has not really achieved what it set out to achieve. When, I'm not even going as back to the legislative history of 1940, but I'm talking about 1996, the 2015 amendment. But yes, I mean, with the institutional arbitration is today something which people will have to be educated about. And it is because today there was a recent survey which was taken by, I think, the Federation of Indian Corporate Law with the Center for Indian and Trade thing, where they said that 60% of the decision in any kind of a commercial dispute, or whether they go into arbitration or not, is decided by the top management. And a lot of time they are actually plagued by the issue of cost, which kind of marries into the problem. Now, people don't understand let's say, whenever I have faced it, like Neeti knows this, for the last 2 to 3 years, I've been recommending, when I am in a negotiation in terms of a shareholders dispute or any commercial contract, and I come in as a disputes partner, I have been suggesting MCIA or any other institutional arbitration. The first pushback we get is in terms of cost. And in fact, Bar and Bench had come up with an article, I sometimes forward that to my clients, saying that please look at the cost factor. Institutional arbitration, like Percy sir rightly said, arbitration is not cheap. But when you compare, in my personal experience, ad hoc arbitration vis-a-vis any kind of a substantive value arbitration, right? When I'm talking about arbitration, all of us over here are dealing with arbitration matters which are more than 50 crores and up. Institutional arbitration like MCIA, I think 10 crore, and Neeti, correct me if I'm wrong, the cost of an administration fee is less than 1%. And the cost of an arbitrator is about same as the fourth schedule, or it is again less than 1%. So you have a fixed cost of 1 and 1%. Yes, Neeti, you can give me some sort of loyalty after this conversation. But this actually makes it, like, people talk about SIAC, LCIA, and all these are foreign seated arbitration. You're looking at a cost. There is people are preferring SIAC in terms of international commercial arbitration. But in terms of domestic arbitration, in terms of international arbitration, India and international party, first, the education, the enlightenment needs to come. That cost, yes, it is, but institutional arbitration is giving you a better result in terms of streamlining of procedure, in terms of cost, in terms of thing. The second, in terms of the time delay, I think everybody is complicit in it. One, there's this due process paranoia, which kind of seizes the arbitration panel, because you feel that if you do not give the time, when some party, they are deploying dilatory tactics and everything, but that due process paranoia, that you don't want your arbitration to be, the award to be set aside on account of natural justice, that delays the process. So I think a lot of more affirmative action needs to come on this due process paranoia. And second, I think sometimes Supreme Court, while promoting arbitration, sometimes I think the interpretation itself kind of causes problem. Like, for example, when you file an extension under 29, which Karthik rightly pointed out, right? Justice Moshinami Bhattacharya, though it was a technical interpretation, had said that extension means when something is alive. So when you're filing an application for an extension of the mandate, you need to file it within the time when the tribunal's mandate is alive. Supreme Court, of course, Delhi and Bombay had different opinions. Supreme Court said that no, you can file it later. Now look at it as a party who wants to delay the arbitration. They will now use that on the basis of a party autonomy and go and file it or withhold the thing. So everything, how do you reconcile when you talk about speedy resolution with all these stumbling blocks which come across? So I think whilst it's easy to say arbitration bar and arbitration council of India notifying this and that, and there's been so many amendments, right? Now you have the Vishwanath committee report, which is kind of set out so many things, but a lot of things need to come together to address this. It is not a quick fix solution. And I think the institutional arbitration in India is growing. But there needs to be more education. Neeti needs to be out on the road more to educate people. But I mean, yes, it's a problem. And the there has to be whilst I agree with Karthik that in India especially, to have a dedicated arbitration bar is difficult, but I think consciously you will need to have that people after a certain kind of an experience that who choose that arbitration. It can't be a post arbitration 6 to 8 p.m. because that again adds to the time. So it's just like a cumulative factors which kind of ends up being a problematic situation for us.
Uh, thanks for the detailed comment. But we will also discuss the challenges. For
Yeah.
example, in a recent arbitration conference that I attended, one eminent arbitrator who also litigates told me, Tarun, there are more people in this hall than the number of arbitrations that go on in India today. So what happens is that the number of arbitrations which happen, are they enough to suffice for the bread and butter and other expenditures of the practitioners? Because if they don't suffice, then obviously they will look forward to supplement their income by doing litigation. That is point number one. Point number two, we will also read out what Justice Roy said, and then I'll go to Niti Sachdeva, Secretary General of the NCIA. Niti, what he said is that attending court is important. It provides a degree of recognition among your peers and colleagues, which is what he acknowledged, which is true. But at the same time, unless we have committed bar members attending to arbitration in more or less an exclusive fashion, the professionalism needed in the field of arbitration is unlikely to develop into a dynamic entity we all hope for. What message is the judge sending? A. B. Do you think we have had that critical mass of work in India that could merit exclusive arbitration practitioners? Over to you for both. Third, if you feel like, also speak on the schedule of fees. If the amount in dispute is in a couple of thousand crores, is Schedule 4 too less to, in a sense, for a professional who's giving his day-to-day work time to this, to accept that kind of fees? So if you could speak on these three.
Yes. Thanks, Tarun. I think a couple of points, right? Thank you that Karthik and Sudeshna and of course Percy and Thairaj spoke about as well. When we speak about, I'll take the cost first because like everybody, the theme seems to be like, is arbitration cost effective? I always say there needs to be a distinction. When you say that arbitration in India is expensive, you're talking about ad hoc arbitration. I'm not saying that institutional arbitration is a panacea to all your problems. Absolutely not. Certain cases, institutional arbitration doesn't make sense. But if you were to do an apple-to-apple comparison, you will see that an ad hoc arbitration comes out to be much more expensive than than institutional arbitration. Karthik gave us an example that where you had a hearing done in February and then the arbitrator telling you, sorry, let's redo it again. Because every hearing that you have in an arbitration, you end up paying the arbitrator. What is the incentive for really me as an arbitrator in an ad hoc arbitration to finish it off? Not really. Where is the accountability? Today, Karthik is talking about this example, but he cannot tell us who that arbitrator is. And you, me, Percy, we may end up with the same arbitrator again. So there's no accountability really there, right? In an institutional arbitration, I can tell you now MCI has done 106 arbitrations. So we have some statistics to talk about. It's just not talking about in the air. We have had cases where I had to ask an arbitrator, a senior counsel in Bombay, after 3 hearings, please recuse. You are not giving a date to the parties. This is not how an MCI arbitration is going to work. They're dear friends as well, professional friends. And he is recused and we have not paid him a penny. He has spent about 12 hours on a matter till date, but he says, Niti, you're right. I'm not able to give justification to the time and the money that I'm spending on the parties. We were able to substitute with another arbitrator who continued from there, got the fees paid. In an institutional arbitration, be it MCI or any other, an arbitrator gets paid at the end of the arbitration. There is no incentive for them to delay the matter, right? So the quicker they do it, they have a sort of an secretariat. Percy talked about a case management. My case managers are on their head, I can tell you. Hearing happened today at 5 o'clock. It got over. Tomorrow, the procedural order has to be out. If it's not out, they get calls, they get emails from a case manager that why it is not there. So institutional arbitration, I'll take a very small example for your viewers, right? Because I need to be out on the road and talk about institutional, Sudeshna said. I'll take this opportunity. Let's take an arbitrator appointment itself. You have an ad hoc arbitration, you need to get your arbitrator appointed, you are in the court. You have spent your time, energy, and money, hired a senior, if not a senior, at least a junior counsel, spent a few lakh to get your arbitrator appointed. In an institutional arbitration, all you pay is 40,000 rupees. Start your arbitration. And within 21 days, if you cannot agree on an arbitrator, institution appoints your arbitrator. Time and money both saved in there, right? Let's talk about what Kartik said, that can I leave my court practice and become an arbitration counsel? I think the idea is not in an Indian jurisdiction to say that leave your court, take up arbitration. I think it has to be a big, good blend, because if you look at a currency of an arbitration as well, when you have an arbitrator appointed, arbitrator fixes up a timeline. He gives you time to submit your statement of claim, defense, all of it. It's only about fixing 1 week, maybe sometimes less than that, for a shareholders purchase dispute agreements and all of it. You probably need 3 days to get your cross-examination done. But the point is that when an arbitrator and both side counsels fix up those 3 dates 6 months in advance, that you will have a cross-examination, stick to it. Then do not take up a matter a day earlier because you get to appear in an SLP before a chief. That seems to be much more lucrative. I think that's where the professionalism comes in. So nobody's asking you to leave your court practice entirely. It is about balancing where you have committed to a time, you stick to it. I can tell you, in courts, if you tell a court is giving you a time that I'm going to list the matter on 24th. And if you tell the court today that, sorry, I have an arbitration listed on 24th, can you accommodate me on 23rd or 25th? They do it. I think it's lawyers who need to step up on it. And there's enough work, Tarun, I can tell you that. If an institution which is less than 8 years old can get contracts to have an MCI clause, come to disputes, have 106 matters, there's enough work in the market for the people.
Okay, there's enough work in the market, and as we get to see it, as your economy doubles, any country's economy doubles, legal disputes go up 6 times. So for every doubling of economy in India, that is a natural fallout. But of course, we get to know it's going to be much more, because India, due to its specific needs, is exclusively spending money in infrastructure that generates more disputes than any other investment. Infrastructure, small and big disputes are generated. I go to Senior Advocate Percival Bilimuria for his intervention on all these issues.
Yeah, so Tarun, I think we've had a very good bunch of comments from everyone on this panel. See, as far as time is concerned, I recall that when Section 29A was introduced in the Act, some of our international colleagues were concerned. And they said that, well, can you really do arbitration which is extremely complex? And I think what they meant is infrastructure, construction law kind of arbitrations within 1 year. There was concern expressed. And even today, you must remember that this timeline applies only to India-seated arbitration, not even international commercial arbitration, where one of the parties is a non-resident or non-domiciled. So we must bear this also in mind. I think what happens, with LCIA and all the other foreign institutions, is that the pleadings, etc., adequate time is given. The key really is that when the arbitration matures for hearing, you have just 1 week, Monday to Friday. It's very rigorous. It's very challenging, even to the counsel, because you have to, hearings are all day, and then you go back to the hotel room, you prepare for next day's matter. It's not easy, but at the end of the week, the effort is well worth it. So that's my little 2 bits on time. As regards fees, I think it's really up to the parties to negotiate. I think the Supreme Court has already said that. I do agree that, Schedule 4 rates are abysmally low. In fact, I know some very good arbitrators who are very hesitant to take up India-seated arbitrations for this reason alone, right? They are abysmally low. But then we also have, you talk about arbitration, like I said at the outset, you have very big ticket matters, and you have puny, tiny matters as well. So it's a good mix. So if you talk about number of matters, that's not really the yardstick. I think you should see the number of matters according to the value in dispute, the claims. that are levied. And again, our act is very robust. There are a couple of issues here, when you talk about time and cost. So, for example, if you don't have an international arbitration and the arbitration clause does not work, then you have to go to court under Section 11 to get an arbitrator appointed. As Neeti said, if there is an institution, the institution will appoint. Now, here there is a Section 11(6)(a) that was introduced, which says that all that the court has to do is to see whether there is an arbitration clause. So we are not looking at validity of the clause. And all that you have to do is just see if there's an arbitration clause and appoint. Now, here, I do believe that a little change is warranted. Incidentally, this provision has not yet been notified, yet it is followed in spirit. And here the problem, Tarun, is that you may have a party which is notifying, the court under Section 11 on a dispute which is a dead dispute, in the sense that it's either subject to res judicata or the timeline is expired. Now, there is something called competence. So the court will say that, look, that is something arbitrator is entitled to decide on his own jurisdiction. So this is something that you should take up the arbitrator. My only function is to appoint the arbitrator or the tribunal. When you go there in Section 16 and you say, look, this is beyond the scope of arbitration altogether because of res judicata or limitation. Now, the law clearly says that, look, if it is a mixed issue of fact and law, then you can decide at the end of the award, at the end of the process. It's not even a threshold issue. So you may actually have a situation where you are right that, look, this is something which has already been decided between the parties, but that issue will be decided at the end. How does this work? Because then what you've done is you have dragged me to court to appoint an arbitrator when I'm not resisting arbitration. I'm only saying that, look, this issue is decided, it's settled, it's over. Why are we getting into this again? And the court refuses to look at it. Arbitrator says, okay, Section 16, I can decide along with the final award. So I am made to run the whole gamut of the arbitration process, and along with the final award, if the tribunal decides in my favor that yes, this is already a dead issue, what is the point of going through this? So there are certain nuances yet that we need to fix in the law as well.
Thank you for sharing those points in detail with all of us. I'll go to Tahira Karanjawala, partner Karanjawala and Company, for her comment.
Thank you, Tarun. So then I think in addition to the problems that all my fellow panelists have pointed out, I think another problem that arises is the stages of challenge after the arbitration is in fact concluded. Now with the institutional arbitration also picking up popularity, and even for ad hoc arbitrations, a timeline being prescribed in the Act, at least I find in my practice that there has been some positive improvement in arbitrations happening more quickly than they used to, say, 5 years back. I mean, perhaps more than that. However, the challenges post the arbitral award are still equally, cause a lot of obstacles in finally getting justice. So although you don't have any appeal on facts, you do have 3 sets of challenges after the award is passed. 2 statutory in the form of your Section 34 and Section 37, and then possibly a special leave petition to the Supreme Court as well. Now, while there are timelines fixed on the arbitrations, there are no real timelines fixed on these in practice. So therefore, you then go back into the court system. You have a situation where Section 34 petitions, although they have to be filed in a sort of time-sensitive way within 3 months, after that, you have them continuing for 3 and 4 years in the High Court. You also have a situation where sometimes, like even a Section 37 is treated like a normal appeal. So there isn't even any you can even seek a condonation of delay in filing a 37, and I've been part of matters where over 200 days were condoned by the court. So I think at some level,
when it comes to an arbitration matter, even the court should treat time sensitivity, with as a priority, because if you allow appeals to be filed with such delay and you allow, then Section 37s to go on for years, then that defeats the entire purpose of the arbitration. In fact, there are situations where a 29A application can be pending for over a year or so, which really defeats the purpose of having a time-bound arbitration in the first place. So these are the, problems that you face when you come to the court. Now, the other problem when you come to the court is the jurisdiction of a 34. Now, this is a slightly double-edged issue, because we have always said all along that there should be a minimum interference by the courts in an arbitration award, and that's important, for speed, efficiency. However, the consequence of that is then that if you do have a patently illegal award, the only consequence is that then that award is set aside, and then the parties go back in a fresh arbitration. I've personally been part of an arbitration where a party asked for a much larger quantum in the claim. They were given a very small quantum. We had to go in a 34. That award was ultimately set aside, but because there's no power of modification, the parties had to go back in a fresh arbitration. That arbitration then took 2 years, and now we went back in a 34. So you have a situation where, because the court doesn't in fact have the power to modify, this actually can, take longer than it would have perhaps had the court had the power to modify the award. This question is now pending in the Supreme Court. A few years ago, there was in the judgment of Hakim, they had said that there was no power to modify an award, but that's now in a reference. So we'll see the decision in that ultimately. But I think this is also a problem that we face, because in India, while judges have, sort of an intervention-based mindset, the only consequence of that intervention is then to send you back into a fresh round of arbitration. So this also creates another layer of delay. So I think that's also something that the courts have to look at seriously while dealing with arbitration related matters after the actual arbitration is over.
An interesting point made by Tahira, that courts should look at these issues much faster than they do. How they are going to do it, that time will tell. But I think this point would be taken up. I'll go to Advocate Karthik Seth for his comment.
I would like to start with what Niti said. Niti was absolutely correct when she said that there is enough and more work and there's no dearth of work. And when you gave an example that there's lesser arbitration than more people in the room, to be very honest, the kind of arbitrations that or either us panelists or even the lawyers whom we mingle around with are working on are mostly infrastructure and institutionalized arbitration, or in specified sectors per se. And there is, when we are talking about litigation and arbitration, in my opinion, what I have felt in my 15 years of experience is that whenever we get into an arbitration per se, we get into a particular timeline in mind that we want to finish it at the earliest. And that is, the kind of professionalism which Niti was talking about. I completely agree that when we are appearing before, say, a Chief Justice of India, if a Chief Justice of India has appointed us as a nodal counsel or a amicus, even when there is no fees involved, we are present there, irrespective of what is, wherever we are busy or whatever we are doing. So if we have committed a date to a court, we have committed to a particular court of law. And as a litigating lawyer or as an arbitration lawyer, when we are committing a date to a particular arbitration tribunal, we try to stick to it as much as possible. In fact, I come from a school of thought where my senior used to not even allow me to take a Passover in his name, where he used to say when a matter is called out at an item number, we should be present there. Don't take up so many matters if you can't be there at the time when the matter is called out. So there have been different schools of thought, and it will evolve in a more better manner with Arbitration Bar of India or whichever manner which we want to evolve it with. The second, coming to what Percy sir pointed out, he's absolutely right when he talks about that we are not even going at the stage of Section 11 whether the issue is even arbitrable or not. I in fact, I'll give us like a 10-second example of a case where on a particular issue, there was a particular decision which was made by an arbitral tribunal. 34 decided, 37 decided, SLP decided, though I would like to joke with Tahira on that. Now we don't stop at SLP, we go up to curative and get it overturned. So, but anyway, like on that point, like, I agree that we have these 3 stages, and when an arbitration is decided in that particular case, an issue has been decided, the other party, who's a big private party, I am appearing for a public sector undertaking, they come up with another arbitration claim and file a section 11 saying that the period which was decided in the arbitration tribunal is so and so, but the interest has to keep accruing. Completely against the law. I mean, like, the arbitration tribunal says that the amount has to be paid from X to Y. You ask for an interest on it, and the Section 11 High Court judge says that no, we cannot decide whether it is arbitrable or not. That has to be decided by the arbitration tribunal. I file an SLP, get it dismissed, I mean, get it allowed, saying this is not arbitrable because this has already been decided up to the Supreme Court. So these are the issues which the law also has to clarify, and law actually has to change. I genuinely feel in the long run, the more and more the law gets evolved, and as Tahira rightly pointed out, Hakim has to be reviewed. And I mean, like, until the time that is reviewed, a particular 34 or a 37 can never be decided in a manner, in a manner that this issue is definitely rightly decided by the arbitral tribunal, but this issue needs a reference. At least the quietus will be attained on particular issues per se. Thank you, Tarun.
Thank you, Karthik, for your sharing those 2 anecdotes from the arbitrations and the litigations you've been part of. I'd go to Sudeshna Guha Roy, partner with Saraf and Partners, for her comment.
There's little to add after my all co-panelists have eloquently put in all the, the relevant and the germane issues in context. There are just a couple of things on the overarching perspective, which I would like to say that this entire move towards arbitration, if we go a few steps back, was to make India the arbitration hub, right? Like right after when people started seeing that Singapore has become with the SIAC and everything, like, let's make India the thing. And like what you said, that today, like they said that for the next 10 years, we are expecting some $1 trillion in investments. The large amount is going to come for in the FDI, some 28% came from Singapore. So infrastructure, energy sector is seeing a huge boom. When you're having all these committee reports, high-level committee and all, government goes and issues a circular in June 2024 that do not go for arbitration. You go for mediation. As in for 10 crores and above, arbitration should not be resorted to. So one, like, I want to underscore the importance that whilst judiciary, bar, bench, everything is important from the government level, they need to make up their mind whether you want to make India the global hub of arbitration or you don't. Close on the heels of the government's objective, like Tahira rightly pointed out, comes the judicial approach, right? Arbitration does not, you make it a time limit, you go to institutional arbitration, but at the end of the day, you need to enforce it. So today, whilst the 2015 amendment gives you a relief that once I file a challenge to the arbitration award, I will need to make the deposit analogous to, what the civil procedure code is, to give that protection. Even if let's say I'm today the judgment debtor, the award debtor. If I don't, I have a matter where there are hundreds of crores, my client is sitting as an award holder. The other side has, despite filing a 34, has not been able to deposit it. I am running helter-skelter for just executing the decree. Because today the execution, there's no time limit for execution. And whilst Karthik said that, sometimes people stick to these things, but there's a lot of pushback from the bench a lot of times. In Bombay High Court, I've said, when you have said that I am in an arbitration and could you get a thing, they said, please make up your mind, you want to be in court or you want to be in arbitration. So it's not that all the time you get that accommodation from the bench. So when you have a multi-million-dollar dispute and you want to take the best legal minds, right? You want to have the senior counsels. And even if the senior counsel makes a thing, then they will look back and say that, no, this matter is more important. You make alternate arrangements. For you to explain to your international clients how this entire situation works in India is mortifying. And I'm being very, I'm understating it, because sometimes, and this, so the way that this entire litigation, this thing we talk about arbitration bar, what about a dedicated arbitration bench? In Bombay High Court, you have only 2 days for a section 34, 37 and all. The rest 3 days, because the assignments are so heavy. And that is because you do not have a dedicated arbitration bench. Considering the amount of arbitration disputes we have, you need to have an arbitration bench. You need to have somebody who is every day hearing a 34 or 37 or an execution which is limited only to a arbitration award. Because at the end of the day, today, we represent, all of us over here, we represent a lot of foreign portfolio investors. At the first sign of a dispute in terms of their exit, they say, Sudeshna, you will win us that arbitration award. How will I enforce it? That enforcement is another 3 years, and another 4 years, because there is no time limit, because the court doesn't have time. So unless and until all these aspects, so I may sound a little cynical, I may sound a little pessimist. Yes, of course, there's hope in the horizon. We have to, but institutional arbitration, implementing the recommendation of the Vishwanath Committee report is only a very, very small part. We need to be cognizant of the fact that there's a larger, more issue at play here. And unless and until everybody consolidates and there's a concerted effort, I don't think so situation is going to change much. Because if you look at realistically, from 2015, post the amendment came, and today in 2024, we are nearly a decade, right? The improvement has been marginal. We can always talk about we have made steps, advancement steps, but it's not that much. So to go towards the global hub of arbitration, first of all, do we even want to become a global hub? Does the government really want to? Because like Karthik rightly said, what are we doing in a curative petition in a commercial dispute? I mean, though it's completely antithetical to the concept. So, I mean, there's just so much of uncertainty. I apologize for being pessimistic and cynical, but somebody really needs to say that these are issues. I mean, we can talk about bar, we can talk about bench and all that, but unless everything comes together, and they need to come together fast. We are in 2024 now, and we've been talking about the same thing again and again.
Point very well taken. Some very important points made by Sudeshna Guha Roy. Today was a very, very interesting episode. Each panelist, put forth his points very strongly. But it all started with Justice Rishikesh Roy putting his points very strongly. That followed by the panelists speaking very strongly. I think this all will lead to something, because no opinion goes out in a vacuum. These discussions will continue. It will definitely lead to something. I would like to thank Neeti Sachdeva, Secretary General of the Mumbai Central for International Arbitration, Senior Advocate Percival Bilimoria, Tahira Karanjawala, Partner Karanjawala and Company, Advocate Karthik Seth from Chambers of Karthik Seth, Sudeshna Guha Roy, Partner with Saraf and Partners. Thank you for coming. Thank you for participating in the show, but also showing a lot of involvement by talking your mind. That is what we wanted. All of you to speak your mind on what Justice Roy said. And thank you to Justice Roy for being as frank as he is. We need judges to be frank. It's nice that he spoke what he did. Appreciate your joining us. Thank you so much.